Good afternoon, everyone. I am Jeffrey from SBF, and it is my pleasure to welcome you to the second episode of SBF IC webinar. The topic for today is Claiming Relief under COVID-19 Temporary Measures Act 2020 and discussion on cost mitigation of projects. Before we proceed further, I would like to touch on some housekeeping issues. Please note that this webinar is meant for general information only and does not contain or convey any legal or other advice. All efforts have been taken to ensure the information provided is accurate as of publication date. Lastly, please note that the organizer and speakers reserve all rights in the material provided. Moving on, if you have any questions during any segment of this webinar, please utilize the Q&A function. In case we receive a lot of questions, we may extend the webinar to 4:15 p.m. We will try our best to answer as many questions as possible, but for the questions that we are unable to answer today, we will work with the panelists and email the responses to the attendees post-webinar. As such, in order for us to attribute the questions to the right attendees, please indicate your name and company in your Zoom profile. For today, we are very honored to have Mr. J. Sathia from Allen and Gledhill, Mr. Jasper Wong from UOB, and Mr. Kenneth Loo from Straits Construction Singapore to grace our event. We will be having two segments consisting of a 30 minutes presentation by Sathia and a 20 minutes panel discussion come Q&A with our esteemed guests. Without further ado, I would like to invite Sathia to present. Sathia, please.
Thank you, Jeffrey. Good afternoon, and hope everyone is keeping well. It has been about 6 weeks since the COVID-19 Temporary Measures Act 2020 came into force, and the focus of today's webinar will be on claiming reliefs under the Act. Let me start off by sharing with you what I intend to cover in the next 30 minutes or so. I will start off with providing an overview of the operation of the Act. Then I will touch on the various reliefs that are available for construction-related contracts under the Act. Then I'll move on to talk about the assessor determination process, which is native to the Act. And then we will apply the lessons learned in the course of today's webinar to 3 actual case studies. COVID-19 has been described as a black swan event. It is unexpected and its effects are unprecedented. And the impact of COVID-19 in the construction industry is particularly acute. In the context of Singapore, we have seen practically all construction works other than critical works suspended. There has been a supply disruption in terms of labor and materials because factories have closed, there have been border control, movement restrictions, and unfortunately for a lot of our foreign workers, they're under quarantine. All of this will invariably affect the progress and completion of construction projects. And I think in all likelihood, the completion of most projects are going to be delayed. The key question on everybody's mind is, so who takes the risk and responsibility for a delayed project? The answer to the question lies in your construction contract. To the extent that the contractor is entitled to claim extensions of time or other time-related reliefs under the contract completion date will get extended, the contractor will get relief. But that may not be the case in all construction contracts because contracts may be actually quite pro-employer. And in those circumstances where there's no time relief for the contractor, no extension of time will be granted, and the contractor is exposed to delay damages or liquidated damages. A lot of contractors will be saying, look, that's rather unfair because I didn't cause COVID-19. I can't be taking responsibility for COVID-19. Why should I be penalized with liquidated damages? But if you look at it from a project owner's perspective, owners will say, well, Mr. Contractor, that's what we negotiated in our construction contract, and we must respect and abide by the terms of the contract. So now you have a tussle between a new situation or novel situation that is creating economic hardships on the one hand, and on the other hand, you have a situation where parties want to strictly enforce their contract. So where does the fairness lie in all of this? From the perspective of the Parliament, Parliament needs to balance not just economic certainty, but also social and economic considerations. If you have a situation where contracts are strictly enforced, you may have a situation where contractors go belly up. If contractors go into liquidation, business gets affected, families get affected, and you create a larger socio-economic type of situation. And that is something that Parliament needs to guard against. So in a situation like this, all I can do is to quote my former boss and Law Minister Mr. K. Shanmugam in his press statement where he says, in a situation like this, it's peculiar. We can't enforce contracts strictly. We need to see what is fair. And what is fair is basically the genesis behind the enactment of the COVID-19 Temporary Measures Act. And if I were to summarize the Act in a nutshell, what the Act seeks to do is to give contractual parties temporary relief from performing their contractual obligation if they are unable to perform their obligation because of COVID-19. So contractual rights and remedies are not strictly enforced, some reliefs are granted. Before we go into the details of what these reliefs are, let me start off with pointing out some of the key prerequisites before a party can claim relief under the Act. First, the Act does not apply to all contracts. The Act only applies to scheduled contracts. For present purposes, a scheduled contract includes a construction contract and a supply contract. The term construction contract and supply contract is as defined in the Building and Construction Industry Security of Payment Act. To simplify things, construction contracts would basically be your main contracts between project owners and main contractors, subcontracts between main contractors and subcontractors, supply contracts for the supply of plant and equipment for construction projects, as well as consultancy contracts you may have with architects, engineers, and other consultants. So all of these contracts are governed by the Act. Second, it only applies to a scheduled contract that is entered into before 25th March 2020. The reason is because if you enter into a contract after the 25th of March, you are deemed to have known about COVID-19, the effects of COVID-19, so you're not entitled to statutory relief. You need to look after yourself when you negotiate the terms of the contract. So the Act only applies to contracts entered into before the 25th of March. Next, the Act only applies to obligations to be performed on or after 1st of February 2020. This date of 1st February was taken on the basis that that's when COVID-19 sort of seriously came into Singapore and affected Singapore as a country. Some of you may have contracts, for example, for supply in China where COVID-19's effect was much earlier. For example, if you have a factory that was shut down in, say, January of this year, anything that is before 1st of February 2020 is not affected by the Act. It only relates to obligations to be performed after the 1st of February. Next, one of the most critical requirements, the inability to perform a contractual obligation must to be a material extent caused by a COVID-19 event, or what is referred to as a subject inability. So the Act only gives reliefs where the inability to perform a contractual obligation is caused by COVID-19 and not because of any other facts or circumstances. So typical examples of COVID-19 caused inability will be, for example, construction is suspended because of a government order, movement control restrictions, inability to obtain supplies and equipment. All of these, if they're caused by COVID-19, that may fall into the definition of what is a subject inability. Next, you need to serve this document called a notification for relief before you can avail yourself the release under the Act. This notification for relief is a fairly simple document to file. The Ministry of Law has set up an online portal. So this is actually an online form. You log into the website using your COPPass or your SingPass. It is a form with about 18 entries, quite easy to enter. You provide details in terms of your contract, the type of relief that you're seeking, description of your subject inability, and you attach some relevant documents and you click the mouse and you're good to go. So it's fairly easy. It's a fairly easy document to fill out, and it is done online by way of a portal. The next point to note about the Act is that the Act and the reliefs thereunder do not go on forever. It only operates during a prescribed period, and that prescribed period is a period of 6 months from the 20th of April, which is when the Act came into full force, up to 19 October 2020. This prescribed period may be extended or shortened, but for present purposes, we will assume that it expires on the 19th of October 2020. And the reliefs in the context of construction contracts will be available in relation to obligations between the period of 1st February 2020 and the expiry of the prescribed period, which is 19 October 2020. So for this period between 1st Feb and 19 October, that's the operative period if you need to be relieved of your obligations. Once a notification for relief is issued, there are various consequences. One consequence is that there is a moratorium against taking legal actions in relation to the subject inability. What that means is, let's say, for example, a contractor has acted in breach of his obligations under the construction contract, and that inability to perform is caused by COVID-19. Once the notification for relief is issued, an employer cannot commence court or arbitration proceedings against the contractor for that subject inability. Once the notification for relief is issued, everything is held in abeyance until the prescribed period expires. But an important point to note is that the moratorium is only against the commencement of court and arbitration proceedings. Many of you will be familiar with the Security of Payment Act. That still goes on. So contractors are still entitled to commence adjudication proceedings, notwithstanding the Act, or even if a notification for relief has been issued. And I think the recent trend is that there have been quite a number of adjudication proceedings that have been commenced. I did one just as recent as last week, where I had my first virtual hearing for SOP application. So I think the legislative intent behind why the operation of the SOP Act has been carved out is because they want to maintain the cash flow of contractors so that they keep adjudications going. Next, once the notification for relief is issued, the release will be in place until the notification is either withdrawn or an assessor determines that the prerequisites have not been met or the expiry of the prescribed period. So the earlier of each of these will apply for the validity of the duration of the reliefs. And I'll come to it in a bit more detail when I talk about the assessor's determination process. So what are the available reliefs for construction-related contracts? The first relief relates to supply contracts. Many of you will be aware of main contractors and project owners entering into supply contracts with suppliers for construction materials, plant, and equipment. A lot of these supply contracts will have deadlines or timelines by which the supplier needs to deliver the construction materials. The reason for this is that the timelines need to dovetail with the overall project schedule for the particular project. And these supply contracts may say that in the event that the supplier does not supply within the contractual timelines, the party engaging the supplier can either buy from a third party and recover the additional costs, or may sue the supplier for damages for late delivery. So these are fairly standard terms in supply contracts. In the ordinary situation, if the supplier is in breach, the party engaging the supplier can sue and recover damages. But under the Act, if the supplier is unable to deliver because of COVID-19, and that inability to deliver occurs during the relevant period, which is 1st February to 19 October, the subject inability is a defense to a claim for breach of contract. That means that the party engaging the supplier cannot sue the supplier for breach of contract if the inability is a subject inability. So that's the first key relief from the Act. Next, many of you will be familiar that construction contracts have a project completion date. And if the contractor doesn't achieve completion by the contract completion date, the contractor is exposed to liquidated damages. To illustrate by way of a practical example, let's say I have a construction contract where project completion or contractual completion is the 30th December 2020, end of this year. And the contractor, because of COVID-19, was delayed, and eventual completion was achieved on the 30th of June 2021. So there's a 6-month delay. Let's say the contractor puts in a notification for relief, and the contractor says, look, because of the suspension, because of the labor disruption, because of the material supply disruption, I am caused 3 months delay from achieving completion. So when the owner wants to impose liquidated damages, what the owner would then need to do is to deduct 3 months from the 6 months delay. So liquidated damages are only imposed for 3 months even though the overall delay was for 6 months, because the first 3 months of delay is attributable to the subject inability, which is caused by COVID-19. So that's the second relief. The third key relief relates to performance bonds. Many of you will be familiar with performance bonds being issued by main contractors as well as by subcontractors. A lot of these performance bonds are on demand or unconditional. So unless there's some fraud or unconscionability, one can call on the performance bond. What the Act does is that it provides like a moratorium period where a bond cannot be called if the call relates to the subject inability. So what happens is, as long as you have a bond, you cannot call on it in relation to the subject inability until after 7 days before the expiry date. So it's only the 7-day window prior to the expiry date can you call if the call relates to a subject inability. The reason why I think legislature had this is because they do not want parties to be trigger happy, and as long as the breach, you straight away go and call on the bond. They want to give parties ample opportunity and time to try to negotiate settlement so that a call on the bond can be averted. This is because a call on the bond may have, or in most cases will have, significant financial impact on contractors, and the intent is to avoid all of that, to defer the call on the bond. But having said that, you can't take away the security that project owners have. So what then happens is it's just literally a shifting of the ability to call to a date 7 days prior to the expiry of the bond. So that's the third key relief. And before I go into assessor's determination, if I were to summarize the key reliefs under the Act in relation to construction contracts, I see the Act as giving contractors a shield against being sued during the prescribed period, a shield from performance bond being called until 7 days prior to the expiry, a shield against delay damages or damages for breach of contract if the breach is caused by the subject inability. So it's literally a shield that gives them relief from all these claims being made against them. And the most important thing to note is the parliamentary intent is not for this Act to cause people to get legalistic, to get contractual, start issuing notifications, start getting into formal dispute. The message really from Ministry of Law is try to resolve your claims amicably. And a lot of you in the construction industry would agree with me that disputes, differences are nothing new in the construction industry. There are always disputes and disagreements over claims for additional costs, extension of time, and a lot of claims are actually resolved and discussed amicably at a commercial level. Contractors and project owners don't run to lawyers at the first sign of trouble. Most claims are actually resolved, and the Act should not change such a behavior, and actually amicable settlement is encouraged before parties resort to formal resolution under the Act. Now, what happens if, despite their best efforts, they are unable to resolve their disputes or differences in terms of whether there was a subject inability or whether one party is entitled to relief under the Act? That disagreement can be referred to an assessor under the Act. Let's look at the assessor's determination process. If I were to summarize the assessor determination process under the Act, I will call it rough and ready justice on a fast track basis. I say rough and ready because the process is really quick. The decision is made quickly for parties, and that is really to give parties commercial certainty to move forward. Because you can't have a situation where parties are in argument and they're stuck in an arbitration over 12 months or 18 months. There's no commercial certainty in terms of how to move forward. And that is particularly important in the context of construction projects because life still needs to go on. The project still needs to get completed. You can't be sitting and waiting for disputes to be resolved. Next key feature, as I said, is low cost. The entire process is actually free of charge. Unlike arbitration, unlike litigation where there are filing fees, there are arbitration fees, arbitrators' costs, the entire process is actually free. For most instances in life, FOC means it's an invitation to try, but this is, the fact that this assessment process is FOC doesn't mean you should try it. It is really a matter of last resort. And I think the reason why Parliament had made this process free of charge is to have everyone to have access to justice. Because now we're in a situation where a lot of businesses are in financial hardship. You don't want to take away a legal remedy because someone can't afford it. By keeping it free, you maintain access to justice. Now, in terms of the assessor determination process, what I've done is I've put them out in 3 slides on a step-by-step basis. Each step is the sequence of the assessor determination process. And in the boxes, I have summarized the key features of the individual steps. It is not exhaustive because of space constraints. If you want to find out more details about each step, what I've done on the left-hand side of the flow chart is to identify the relevant regulation where the steps are elaborated on. And all of this information can be found in this piece of legislation known as the COVID-19 Temporary Measure, Temporary Relief for Inability to Perform Contracts Regulations. Now, it's a bit of a mouthful, so I will just use the word regulations. So what happens after a notification for relief is issued by a party? They try to negotiate a settlement, but they can't settle despite their best efforts. Either party to the contract has the option of applying to an assessor for a determination. Just like the notification for relief, an application for assessor determination is quite a simple, straightforward process. It's again an online portal. You go in, you fill up a form, 15, 16 questions, you put in your supporting documents, you click the mouse and you're good to go. Fairly straightforward, very low cost and very quick. But a key point to note is that there is a deadline by which an application for assessor determination needs to be made for construction contracts. That deadline is 2 months after the end of the prescribed period. So that will take us to 19th of December 2020. So I think Parliament intended for a fairly generous deadline to make an application. The reason is because if, let's say, the Act was drafted such that you need to file for an assessor determination within, say, 14 days or 30 days of receiving a notification for relief, what would happen is that parties will be more focused on trying to prepare for the assessor determination than trying to resolve their issues amicably. So by giving a fairly generous deadline until the end of the year, parties can focus on trying to resolve matters amicably. And if they really can't, as a matter of last resort, they may refer for assessor determination. So once the applicant has lodged the application, the registrar will go through the application to make sure that everything is in order. Once everything is in order, the registrar will send a notification to the applicant, and as well as the response form for the respondent to respond. That's step 2. Step 3, once the applicant receives the confirmation from the registrar, the applicant must then serve the documents received from the registrar on the other party to the contract. In addition to the other party to the contract, the documents would also need to be served on other persons specified in Regulation 14.7. Now, who are these other persons? In construction contracts, it's quite common to have performance bond, where the dispute is between, for example, a main con and a project owner, and there's a performance bond. The application also needs to be served on the bank or the insurance company that issued the performance bond. In some construction contracts, you may have a parent company guarantee. For example, the parent of a contractor may give a guarantee. If you have a situation where there's a parent company guarantee, the papers will also need to be served on the parent or the guarantor under the contract. So that's step 3. Moving on to step 4. Once the applicant has served all the documents on the respondent, the applicant will need to submit a document known as Declaration of Service on the registrar. This is just a confirmation that all the documents have been properly served on the respondent by the applicant. And if there are actually legal proceedings underway at a point in time, the papers would also need to be served on the court or the arbitral tribunal. Step 5 is where the respondent comes into the thick of action. The respondent within 5 working days needs to serve the documents in terms of the response form on the online portal as well, stating what's the response to the application for relief. That's step 5. Step 6, once the claimant has put in the documentation, the respondent has put in the documentation, the registrar will review all of it. If everything is in order, the registrar will then appoint the assessor or assessors and inform the parties on the identity of the assessor that's been appointed. That's step 6. A question that may be on a lot of people's mind is, who is this assessor? How qualified is this person? Does he have construction experience, for example? To qualify as an assessor, you must either be a lawyer or an accountant, or you must have at least 3 years working experience in the relevant field. So in the context of construction, you may be an architect or a quantity surveyor, but 3 years working experience. The bar is actually quite low. It's not a very high bar you need to qualify as an assessor. And I think the reason why Parliament had set the bar low is to be able to have a very wide pool of assessors, because Parliament anticipates there will be quite a lot of applications for assessor determination. And because they want the process to be fast, they want to have the benefit of having a large pool of assessors that they can appoint. So that's the how to qualify as an assessor. Once the assessor has been appointed, he or she will then have full conduct of the matter. Ordinarily, in a court or setting or in an arbitration, there will be a physical hearing involving the parties, hearing of evidence and cross-examination. There's none of that in an assessment determination process. By default, the hearing will be conducted by an exchange of emails. That's the default position. Where in cases which are quite straightforward, where the case is quite clear from the documents submitted by the party, the assessor may even dispense with even having a hearing and may decide on the documents itself. However, if the assessor is of the opinion that the interest of justice will be better served if there's an actual online or physical hearing, the assessor may direct for the hearing to be conducted. So that may either be online by a platform like Zoom or a physical hearing. But ultimately, again, the overarching consideration is quick, fast, and low cost. And another point to also note, and I say this with a very, very heavy heart, parties cannot be represented by lawyers at the assessor determination process. It's all part of keeping low costs, because some people may feel, look, lawyers are expensive. If one party has the benefit of lawyers, the lawyer may bully the other side, small-time contractor who's got no money to hire lawyers. So to level the playing field, advocates and solicitors are not allowed to attend at hearings. You may have lawyers advising you in terms of the process, helping you draft the submissions, but if there's going to be an actual hearing, you will need to conduct it yourself. Final step, once the assessor has made a determination, the assessor will inform all the parties of the outcome of the determination. And a key point to note, assessor's determination is binding and there is no appeal. So unlike a court litigation scenario where if you're dissatisfied with the decision of a high court judge, you can take the appeal to the Court of Appeal, or in the context of arbitration, in some circumstances, you can apply to either set aside the award or appeal on a question of law. For assessment process, it is binding, it is final, there is no right of appeal. So that is a key consideration that parties need to have in mind, because the process comes with some risk. And in a very quick, rough, ready type of process, you may not get the outcome that you think you should or you are entitled to, but there's no right of appeal. So that sort of sums up the assessor determination process. Now, I've shared quite a lot of information with you. Let us quickly try to apply some of this information to 3 case studies. First case study, fairly straightforward. Contractor engages supplier to supply specified quantities of construction material on or before the 6th day of every month for 12 months. The contract states that if the supplier fails to supply by the timelines, the contractor can engage another supplier and claim any additional cost from the supplier. Because of COVID-19, the supplier is unable to supply. The supplier issues a notification for relief. So the first question is, can the contractor engage another supplier who's able to supply at a much higher cost and claim the additional cost from the supplier? Without the act, the answer to this question is yes, because the contractor is just exercising his contractual right to hire somebody else who can do it and to claim the cost against the original supplier. But with the act, the answer is no, because this is a subject inability, and because the supplier has issued a notification for relief under Section 6.5 of the Act, the contractor cannot go after the supplier for damages for breach of contract. Second question, if the supplier fails to meet the timelines after 19 October 2020, can the contractor claim additional costs then? The answer to this question is yes. The reason is because the Act only applies for the duration of the prescribed period. After the prescribed period, the contract applies to its full term. So the supplier cannot claim relief for inability to perform his contractual obligations after the 19th of October 2020. So that's the first case study. Second case study, this is a construction contract between an employer and a contractor, which has what we call a closed list force majeure clause, meaning the force majeure clause is drafted such that it only identifies certain events as qualifying as force majeure. And because COVID-19 does not qualify as force majeure, there's no entitlement for extension of time under this contract. And the extension of time entitlement under the contract is limited to acts of prevention or breach of contract by the employer, which is quite similar to the EOT clause in the REDA's form of contract. And the contract also provides that if the contractor is granted extension of time, the contractor is entitled to claim prolongation costs. So what happened in this factual scenario is the project is completed late because of COVID-19. The contractor issues a notification for relief. but because the owner does not intend to impose LDs for the period of delay, because the owner knows that under the Act, you need to discount your computation of the LDs if there's a subject inability. But what happens here is that the contractor submits a claim for extension of time for the period of delay that the subject inability was operative. And the reason why the contractor does submit a claim for extension of time is because if he gets the time, he gets the money under the contract, because that's what the contract says. The question then is, does the Act oblige the employer to grant EOT and thereby give rise to a claim for prolongation costs? As I mentioned earlier, the Act gives contractors a shield against LD claims, a shield against call on bonds, a shield against legal proceedings being commenced for the duration of the prescribed period. Claims for extension of time, claims for loss and expense, claims for additional payment, additional costs is not governed by the Act. That is entirely governed by the terms of the contract. So that's a critical point to bear in mind. The Act doesn't say that a project owner or main contractor needs to grant extension of time or pay loss and expense. Those matters are left to be determined in accordance with the terms of the contract. The Act only grants reliefs from delay damages and liquidated damages. So a key point to note. Final case study. Design and build contract between employer and contractor provides for a completion date of 15 September 2020. Between 15 June and 15 July, contractor's progress was affected because of disruptions to labor and material supply. So there's subject inability. During the same period, the contractor could also not progress because parts of the work were affected by a design flaw. And because there's a design flaw, the contractor had to rework his design and rectify works based on the rectified design. So what you have a situation where there is an inability to perform because of COVID-19. At the same time, there's also an inability to perform because there's a defective design. So there are two competing factors in play. And in this case, the contract says that if there's no EOT entitlement, if there's concurrent delay, the employer takes the view that the dominant cause of the delay is the defective design and intimates that LDs will be imposed by calling on the performance bond. The contractor issues a notification for relief and the matter is referred for assessment. How will the assessor decide? You know, honestly, your guess is as good as mine. And I don't say this to sort of disparage the assessor process, but in a situation like this, where there are complex facts, there are complex documents, there's design issues and COVID-19 issues, it is very difficult to say how an assessor will decide. And because it is difficult to say, either party has a risk that the decision may go against the party. And why I raise this issue of risk is because I think what is important for parties is to think about whether you actually want to refer claims for an assessor determination when you have a rough and ready process where the outcome actually may not be in your favor. So there's actually a risk that the outcome may be unfavorable. And a situation like this, again, I think one of the main points that Ministry of Law is emphasizing, and what I want to emphasize as well, is try to resolve your claims amicably. Because when you talk about amicable settlement, commercial settlement, the outcome is within your control. Once you refer it to an assessor, it is out of your control. Whether you win or lose is in the hands of the assessor, and the outcome may not be helpful. And a few other practical considerations just to think about, just to wrap up, is enforcing the contract terms strictly may not be the best solution to the situation at hand, because if you enforce the terms strictly, you run the risk of your contractor going belly up. And if the contractor goes insolvent and has to be terminated, that is not in the best interest of the project or the project owner. The reason is because once you get a replacement contractor in, it's going to cost the project owner more money, and the project is invariably going to be delayed, and you're going to have issues with warranties on design and construction because the replacement contractor may not be prepared to warrant the works done by the original contractor. So there are practical considerations to think about when it comes to termination and insolvency, and owners need to think about what is the consequence of enforcing my contract terms strictly. It may not necessarily be in the best interest of the project as well as the owner. Next, you need to think about the financial position of the parties, because of COVID-19, you know, people may be financially insolvent, suppliers may be insolvent, people may not be able to perform their contract. So those are conversations you probably need to have now to assess financial positions to make sure the project can move forward. Next, now that the dust on COVID-19 is settling, there's likely to be a real scramble for resources in terms of labor and equipment. So you need to think about, how do I ensure that I secure the labor and the equipment I need to bring my project to completion, because every other project will be rushing to completion. And all in all, I think parties are required to discuss resolutions in the interest of the project to see how best to quickly conclude the project in the most efficient way as possible. And if parties are unable to resolve their issues amicably by commercial discussions between themselves, there are other avenues open as well. One of it is actually the SIMC, Singapore International Mediation Center's COVID-19 protocol, which allows parties to mediate through the SIMC protocol. And the mediation is also, again, low cost and quick to alleviate difficulties of parties to try to amicably resolve their differences. Yeah. Thank you.
Thank you, Sathia, for the informative presentation on the relief claiming process under the COVID-19 Act. Before we proceed onto the panel discussion, we will be launching a short poll for the attendees. So attendees, please respond to the poll in your own time. I would also like to remind the audience that if you have any questions during any segment of the webinar, you may utilize the Q&A function. We will close the poll 10 minutes later, and we'll discuss the results right before we end the webinar. We will proceed to the next segment of our webinar today. I would like to kick off the panel discussion by asking Kenneth a few questions. Kenneth, in the first episode of, just give me a second. So in the first episode of our SBF IC webinar, we actually ran a poll asking the attendees about rising costs in their projects. So the poll results a month ago showed that 89% of the attendees felt that their cost of business has been moderately or greatly impacted by COVID-19. I would imagine you would have some insights into this topic. So could you share with us what are some of the rapidly rising costs in your company that you have faced in the last few months due to COVID-19?
Okay, I think if you look at the cost structure that the construction firms are facing now, of course, during this period of we are just out of CB today officially, there's idling costs. But having said that, being out of CB, a lot of construction firms, as mentioned earlier on by the authorities, would not be able to start immediately. So this continuing idling costs will still be faced by construction firms. But in terms of the rising costs that you mentioned, going forward, in order for us to restart, which is in the mind of a lot of our fellow contractors, is to satisfy the requirements that is put in place by the authorities, namely safe housing, safe worksite, and safe workers. All these three items have actually cost implications. When you talk about safe housing, you're talking, I think there was just an announcement yesterday on the specs and requirement for workers' dormitory that is coming out for people to restart, where we have to have a safe housing. The specs is actually higher, and of course that comes with cost. And I think this is one thing that people have to grapple with. In terms of a safe worker, it has also been announced that for this immediate period, we need to do swab tests regularly, and this swab test is also a cost. Currently, it has been announced that the government will absorb the cost till August. After that, it's still unknown what will happen. But if this continues, it will be quite a big burden to the industry. Just for example, I mean, you look at, it's reported that about 300,000 workers in the construction sector. If each worker has to be swabbed twice a month, each swab is $200, and the amount is actually quite substantial, in hundreds of millions for the industry per month. Of course, the third item of safe worksite, the social distancing part, is also something that we need to work on. Going forward, we need to plan our work in such a way that they are in bubbles, in groups of people going into the work site. Not everybody is going together. By doing so, there will be loss of in productivity. We need to schedule the workers groups by groups. So in that sense, there will be definitely extra costs that the industry will have to face with. So these are the three broad items that we foresee that has a big impact on the cost structure within the industry.
So what are some of the measures your company has adopted to cope or mitigate on some of these issues?
I think these are still evolving. Currently, what we are trying to do is to make sure that we plan efficiently and make sure that to get started. I think now in a lot of our fellow contractors' mind is basically to get started. We have been actually idling for the last 2 months, and seems like this will continue until we resolve this issue. So I think that is the main thing. If you get started, then you can actually run the see how we run and perhaps make our operation more efficient in order to save costs.
Thank you, Kenneth. Jasper, I'm sure you have also been approached by some companies who are trying to deal with their cost issues. So what are some of the issues that you have come across recently?
Yeah, thanks, Jeffrey. I think I do echo, what Sathia and Kenneth have mentioned, whereby, we are really in unprecedented time, whereby you have a drop in your revenue, but your costs continue to be incurred, right? And looking at the around the region, we have clients that we constantly keep in touch with. And from our survey, we know that the construction sector, recently there was a survey done regards to the regional construction companies. I think Singapore and Malaysia looks like they will have the largest decrease in terms of the construction sector itself. So, and it is quite right that I think Kenneth has also mentioned in terms of the safe workplace, the labor, and the work site. I mean, these are things that that we're constantly being asked, talk about by our clients. If you look at the construction value chain itself, the maybe up to 50% or 55% of the costs are materials. Then you have 25-30% are labor, and out of this is already 80-85% of the cost, right? And these continue to be incurred. And of course, you also have the financing cost that is being incurred while your machinery lay idle. There are other things that we are also seeing because of the geopolitical situation, with the US-China trade war. There's also affecting a lot of the sourcing and also logistics. What we are also being mindful of is when we look at the region itself, those who are actually importing materials, obviously those are getting affected, and some of the manufacturers are also moving out of China, maybe setting up the manufacturing facilities in this region. Of course, the FX is another issue that some of the contractors need to deal with. If you're Indonesian contractors, if you import construction materials like steels or granite, because of the depreciation in the rupiah, you are currently will get hit in terms of your profitability. Of course, the last thing that we always have to bear in mind is in terms of the legal and the nature of the contract, which Sathia has mentioned already. What is in your contract in terms of what you can seek relief for, and how do you mitigate those costs in terms of when you have a squeeze in your liquidity.
So currently, are the financial institutes providing any assistance to the local companies to deal with these issues that has surfaced?
Yeah, that's a good question, Jeffrey. I think this COVID situation actually brought about quite unprecedented sort of government programs or relief programs throughout the world. And previously, you will see that in an economic downturn, the government will push out a lot of physical stimulus package. But this time, the government is very precise in terms of direct monetary policy that they actually inject cash into the economy, such as we're seeing the government's requirement on debt moratorium, not just in Singapore, direct cash supports to businesses, wage subsidies, deferment of taxes, credit guarantees, cash to household. So these are a lot of the very direct and also specific policies that are being implemented by the government. In the financial side, obviously Singapore, we have seen the temporary bridge loan that has been implemented by ESG. So you can get up to 5 million of facility interest cap at 5%. You have the SME working capital loan, which is up to a smaller amount, which is at 1 million, and you get a 1-year deferment in your principal. Then moving along, if you are looking at trade loan relief, which is from the enterprise financing scheme, that the amount can be up to 10 million, but it has to be related to financing your trade-related activities. Of course, from MAS perspective, MAS have also pushed out the low interest cost facility for those who are applying for ESG loans at 0.1% funding to the banks. So the banks will then be able to pass on these savings to the companies directly.
So looking at the multiple rounds of budgets announced by the government in the last few months, and with the latest being announced last Tuesday, do you have any advice for companies involved in the infrastructure sector?
I guess the Fortitude budget actually also has brought about even more relief in terms of foreign worker levy that we heard about in terms of rebates and waiver for up to 2 months. I think Kenneth also mentioned about the swabbing activities that needs to be borne by the construction companies. And the government have also, I believe, come out to say that they will co-share with the additional costs for businesses that were incurred, because of the newly imposed requirements to resume their activity. So this really helps a lot. And then, of course, the wage support subsidies have rise to 75% and will be paid, will cover up to August. So these are all very tangible support for companies, for contractors as well. And I believe that the government is doing the right thing. One thing that Sathia has also mentioned, which I echo as well, is in terms of before you take the step in terms of whether you want to go to activate the COVID relief program, or you go for arbitration, do think about collaboration, or talk to your employer, paymaster, developer, or talk to the main con or the building material supplier. I guess because I think for construction, it is a value chain, right? And you will require each part of the value chain to actually perform, and to actually default on your subcontractors or your suppliers may not be the best solution for you when you are trying to complete the project. So these are some of the things that I guess for the larger main cons who actually holds more of the what do you call it, if you want to call it bargaining power or whatever, those are the things that probably will be in their mind in terms of trying to complete the project versus how do I manage costs from that perspective. Yeah.
Thank you, Jasper. We have a questions here from the floor, which I would like to open this up to the panelists. So someone have asked if we are to rely on the COVID-19 for EOT, can we claim for loss and expense for the extension of time and cost implications? And if yes, for the cost, what are the items that we can claim for? Sathia, would you like to take this up?
Yeah, so as I mentioned in one of my case studies, I think it's case study 2 or 3, the Act only gives you a shield against claims for liquidated damages. So if a project owner is trying to impose liquidated damages on you, you can potentially rely on the Act if the delay is caused by COVID-19. The Act doesn't govern claims for loss and expense. The Act does not govern the rights and obligations of extension of time. All of that needs to be determined in accordance with the terms of the contract. And I think what a lot of contractors are also doing right now, and validly so, is that they are putting in their contractual claims for extension of time and loss and expense in accordance with the terms of the contract. And separately, they are also issuing the notification for relief under the Act. So they're doing both at the same time. And I think the reason is because relief under the Act is more of a defensive action. So they're raising the shield, yet at the same time, they're trying to claim contractual entitlements by giving notices under the contract. And I think the overall message really is this. If project owners or main contractors, if you receive a notification for relief under the Act, you shouldn't view it as an invitation to get into a big fight, right? See it as an invitation to negotiate. See it as an invitation on the part of the subcontractor or the main contractor to say, look, I'm having difficulty. Can we discuss how best to try to resolve it? And if we sort of have a positive attitude towards trying to reach a fair and amicable resolution, I think that's good for the overall industry.
So what about machinery rental, idling, monitoring, material, and manpower costs? I mean, can all these be claimed?
All of this, again, will be determined in accordance with the terms of the contract. The Act doesn't seek to rewrite entitlements under the contract other than the limited reliefs in relation to delay damages for breach of contract. So, claims for additional payment, loss and expense, prolongation costs, extended preliminaries, whatever you call it, all of that is purely governed by the terms of the contract, and your claims need to be made in accordance with the terms of the contract.
So in that case, right, can the companies wait until they receive a claim from the client before they serve a notification for the relief, or do they have to serve the notification before they receive any claims from the client?
I think a lot of contractors will want to be careful. They may want to just issue the notification for relief first as a defensive action. The problem is that you cannot claim relief unless you issue a notification for relief. And what a lot of the contractors would want to be mindful of is that sometimes you may have a project that's got a completion date in 2 years' time. And there's a window period by which the notification for relief needs to be issued, the assessor determination that I said there was a deadline to apply for as well. So rather than waiting it out, and not doing anything and waiting for the claim, some of them are a bit careful. So what they will do is they will just issue the notification for relief first as a preemptive defensive action rather than waiting for the claim to surface.
So what happens if the respondent does not respond after 5 days?
Okay, I think that's in the context of the assessor determination. So there's a 5 working day window for a respondent to respond. If the respondent needs more time, 5 working days is not enough, the respondent can take out an application for an extension of time to the assessor or the registrar. If the respondent doesn't respond because he just ignored, he doesn't care, what will happen is that the assessor has the power to make a determination in the absence of a respondent. The reason is because you can't have a situation where the whole assessment process can't proceed because somebody doesn't want to get involved. So that would take away the efficacy of the process itself. So under the Act, the assessor has the power to make a determination even in the absence of the respondent making a response.
So is there a limitation to who can utilize this Act, the subcontractors, the subcontractors, the people down the chain?
As long as your contract falls within the definition of construction contract or supply contract under the Security of Payment Act, you can use it. So if you're talking about subcontracts, in principle, the answer would be yes. So effectively, if you're being hired to do construction work in Singapore, in principle, you should be entitled to relief under the Act, even though you are the 2nd tier or the 3rd tier. So it doesn't only apply to main contracts, it applies to subcontracts and subcontracts for construction work.
What about plant hire agreements? Would the Act cover such as well?
Again, if your plant hire agreement falls within the definition of supply contract within the Act, then it will be covered. So it all goes back to how the definition of supply contract and construction contract is under the Act. the SOP Act, the Security of Payment Act.
Thank you, Sathia. So, so a while ago we ran the poll, and right now we are showing the poll results from today. So I think what's interesting to note is that right now, okay, on the presentation slides, I'm actually showing the results from our previous webinar. So in the previous webinar, we have around 92% of the attendees who felt that their revenue has been impacted, and around 89% felt that their cost of business have been impacted. And from today's poll, what I'm seeing is that we have almost 97% who feels that their revenue base have been impacted, and that around 95% feels that their cost of business have been impacted. So it seems that in terms of sentiment, people are feeling the negative impact from the COVID more. So would any of the panelists, do you have anything that you would like to say about this?
I think, Kenneth, I think it's more clearer now that the impact initially during the your first seminar, probably the duration of to restart, perhaps people were thinking that we can restart earlier. From the data that we and the conditions that we are experiencing now, I think industry, especially in the local context, we can see that perhaps maybe a lot of work will probably be only started probably in August or perhaps maybe September, that we get back to the new norm. And the new norm perhaps will probably be very different from the pre-COVID. So I guess in terms of the top line, we can see that the revenue generated would be definitely less than what was budgeted before that. In terms of cost, with the measures that I mentioned earlier on that is in place, I guess the cost will definitely increase. That's why you probably see the polls result that way. That's my opinion.
Yeah, it seems that from this poll, we are also seeing that more than 82% of the attendees, their projects have been delayed due to COVID, whereas a month ago, only around 60% expected that their projects will be delayed. So we are seeing that more and more people are feeling the impact. So Sathia, Jasper, I mean, I'm sure you have encountered with a number of companies. So is this the same sentiment that you're getting from the who you're talking to?
Yeah, I mean, we are certainly seeing a lot more parties putting in their claims, because ordinarily when COVID-19 first came about, and echoing Kenneth's point, people were not able to appreciate the full impact and extent, because some people thought, okay, maybe I have a bit of float or a bit of buffer within my program. If this thing goes away in 2-3 weeks, I can absorb the delay and I'll still complete in time. But looking at where we are today, the impact on the workers, impact of the BCA's measures in terms of not allowing all construction to immediately start, or doing it over phases, and the various other measures that need to be implemented before this thing can happen, I think a lot of them are very wary of the long-term impact that this is going to have, which has sort of led people to be a lot more proactive in terms of putting forward their claims and having those conversations with their contracting parties to try to receive, sort of achieve a resolution in terms of how we apportion the time and cost impact of COVID-19.
Yeah, I think from our side as a bank, obviously the pressure is a lot more now in terms of clients coming to talk to us in terms of how they can optimize their debt repayment profile, in terms of helping them take them through during this difficult period. I guess from our side, in terms of looking ahead, what will happen, after the relief expires either end of this year or in October, whereby will the companies continue to be able to operate or if the owner may decide that, oh, you know, it's just too difficult, you know, they may exit the business, right? So these are the things I think that will probably be on their mind in terms of, you know, how they move forward in the next 3-4 months, because, you know, from now until October, you know, they have time to think about and need to start preparing, you know, after when the relief no longer applies and everything suddenly comes due. How do we deal with that? And I think this needs to come through collaboration and also discussion between each of the commercial parties, so to allow, you know, how do we gradually, you know, go back to, well, I wouldn't say normal, but go back to new normal. There was a question regards to, you know, if I really tendered for a project and now because of COVID, you know, with all the new regulations that are coming in, you know, how do I actually recover my costs, right? So these will be interesting questions in terms of whether, you know, your employer or the government agencies allow you to make changes to your costing or your bid packages because of the new law, change in law that's coming about.
Thank you, Jasper. We are coming to the end of our webinar today. Before we end, we would like your help to respond to our feedback poll. I would also like to thank our 3 panelists for spending time with us this afternoon. At the same time, I would like to thank our attendees today for your great list of insightful questions. We still have a fair number which we are unable to respond to. What we're going to do is that we will be working with our panelists, and once we collate all the responses, we will email out to all the attendees with the collated answers. Also, the next episode of our SBF IC webinar is slated to be held on the 2nd of July, and we will be looking at mediation and arbitration as means to resolve COVID-related disputes in infrastructure projects. So lastly, if any of you would like to find out more about SBF Infrastructure Committee or to join our interest group, please scan the QR code on this slide. We will be sharing the deck of slides with the attendees post-webinar. Once again, thank you everyone. Thank you Sathia, Jasper, Kenneth for joining us today. Please stay safe and healthy. Goodbye.
Thank you.
Thank you.
Thank you.